Good evening, everyone. Good evening, sir. I, Kritika Goyal, extend a warm welcome to you all to this exclusive session by LiveLaw Academy on the topic Res Judicata and Res Subjudice Explained. We are deeply privileged to have with us an eminent legal luminary, Justice Ved Prakash Sharma, sir, former judge of High Court of Madhya Pradesh and former chairperson of Madhya Pradesh Law Commission, Bhopal. Justice Sharma, sir, has an illustrious career in the Indian judiciary which spans over 3 decades. It is marked by distinguished service in several pivotal roles as Registrar General of Madhya Pradesh High Court and later as Chairperson of MP State Law Commission. Sir's contribution to law reforms, judicial education, and institutional development have been both impactful and enduring. Sir's extensive work includes submission of 8 vital reports to the state government addressing issues such as repeal of obsolete laws and reforms in criminal justice system. In the academic sphere, Sir has delivered more than 200 thought-provoking lectures at esteemed institutions such as National Judicial Academy, the Central Academy for Police Training, and various state judicial academies across the country, thereby shaping generations of legal minds. Today, we are privileged to hear Sir's insight on res judicata and res subjudice. Without further ado, please join me in welcoming Justice Ved Prakash Sharma. Sir, we are truly honored by your presence and we are eager to learn from your wisdom on this important subject. Sir.
Good evening, friends. And thank you very much, Kritika, for the introduction. Now, in this session, we are going to discuss and deliberate about 2 fundamental legal principles of universal importance: res subjudice and res judicata. These 2 principles have been incorporated in the Code of Civil Procedure by way of section 10 and 11 respectively. In this session, we would like to discuss about the meaning, the concept, the origin, the conditions of applicability, and the meaning of various expressions used in section 10 and 11. Apart this, we will also deliberate on certain collateral and incidental issues with regard to res subjudice. Thereafter, we will deal with the issue of res judicata, and again we will try to find out that ultimately what is the meaning of this expression, what is the origin of this expression, why this expression has been included in the Code of Civil Procedure, what are the essential elements to put into action, what are certain other incidental issues related with this principle which need to be understood so as to have a broad concept in a clear manner about the issue. Friends, these 2 issues are of universal importance in the sense that no judicial system can effectively work without these principles. Judicial decision making has 3 fundamental aspects. One is the fairness, the second is the certainty, and the third is finality. And these 2 principles together just deal with these 3 aspects of judicial dispensation, that is fairness, certainty, and finality. Friends, we are all aware that if the decisions of the court are not giving finality, then it may create a situation where numerous litigations may be there with regard to the same issue. At the same time, if the same issue is being tried and considered by multiple courts having jurisdiction, then it may create chaos in the sense that one court may reach one type of findings, the another court may arrive at other type of findings. There may be conflict of findings, and again, the justice may suffer. Therefore, it is necessary that the decisions rendered by the courts should have finality. Apart that, there should be no multiple proceedings at the same time. Now, the first principle, res subjudice, incorporates the doctrine that there should not be parallel proceedings or litigations with regard to the same issue, because that will not only be a wastage of the precious time of the court, it will also be putting the defendant or the plaintiff, as the case may be, to a harassment. Apart this, it is against public policy that there are multiple trials and proceedings with regard to the same issue. That's why we find this principle in section 10 of the CPC. Now, res subjudice. What is the meaning of res subjudice? Res means matter. Matter meaning by any issue, a dispute, a subject matter of its dispute, that is matter. And subjudice means under judicial determination, under judicial consideration. So, when we put these two terms together, then res subjudice means a matter which is under judicial consideration. Now, this res subjudice is an expression of Latin origin, and so many Latin concepts have been borrowed by the common law, and from common law, these principles found way to the Indian judicial system, because most of the law that we find today was enacted on the lines of the common law. Now, res subjudice means matter which is under consideration. And if we go through the language of section 10 of the CPC, entitled Stay of the Suit, then it says that no court shall proceed with a trial of a case in which matter directly and substantially in issue is also involved in the earlier suit between the same parties or between the parties litigating under the same title. Basically, to put it very briefly, it says that if there is a trial going on with regard to a certain dispute, then that dispute cannot be tried by another court of competent jurisdiction, because two parallel trials are bound to create so many complications apart from putting the parties to a lot of harassment. Now, the expressions which have been used in section 10, they need some clarification. One thing is that here there are two suits, both are pending in the court, and the mandate of law is that the subsequent case, there is a previous case, there is a subsequent case. Now, the subsequent case will be stayed till the determination of the list or the determination of the dispute in the previous case. But it requires certain conditions. Now, what are these conditions? Firstly, the parties should be same or they must be litigating under the same title. What does it mean? So if there are two persons, A and B, A has filed a suit with regard to declaration of title against B in a court of competent jurisdiction. Now, B subsequently also files a suit with bringing certain other incidental matters into controversy before another court seeking some sort of permanent injunction and declaration against A. So now if we examine that the subject matter or the issue which is pending before the previous court is almost identical with the issue which is pending before the subsequent court. Same parties are there. Here A is the plaintiff, in another suit, B is the plaintiff. There may be a situation that B has died. So now the LRs or the persons who are claiming through B, if they have filed the suit in the second court, then it means same because they are previous to the parties which we are litigating earlier in the earlier suit. So in such a situation, when the parties are the same and the matter directly and substantially in issue is directly and substantially in issue in the previous suit, then both the suit cannot travel together. Then the subsequent suit has to be stayed in view of the principle which we find in section 10 of the CPC, because that is the mandate of law. No court shall proceed with the trial. Now, when we say that directly and substantially in issue, it is clear between the same parties, means parties are same or their privys are there or their representatives are there. But then what is directly and substantially in issue? This we need to understand with the help of certain examples. In one of the case, Aspijal, that is a very illustrative case, very important case. In this case, what happened? That plaintiff who was the owner and landlord of the premises, he filed a suit before the judge of small causes court for eviction of the tenant B on the ground of bona fide need. In most of the state legislations, bona fide need of the owner is a ground for eviction for the tenant. So he filed first suit on the ground that I require these premises bona fidely for my own use. After some time, he filed another suit. And this time again a suit for eviction regarding the same premises, regarding the same tenant, but the ground was that the defendant has failed to pay rent of the premises for a considerable period. This suit was also filed in the same court. Same court means the court of judge small causes. After some time, A prefers third suit before the court, same court. And this time, the plea for eviction is based on a ground that the defendant has failed to pay the rent of the premises continuously for a period of more than 6 months right before the institution of the suit. So if I say that the suit is instituted on 1st of April, so plaintiff says that till 31st of March, more than 6 months have elapsed and the defendant tenant has not tendered or paid the rent of the premises. Now, when this third suit was preferred before the court, the defendant submitted an application under section 10 of the CPC, raising the plea that subject matter, the parties, the issues in this third suit are identical with the second and the first suit, and therefore, in view of the mandatory provisions of section 10 of the CPC, the trial in the third suit is liable to be stayed. This ground was challenged and contested by the plaintiff, and he said that no, property is same, the parties are same, but the issue is different. It was submitted on behalf of the plaintiff that in the first suit, the issue is bona fide need. If I fail to prove my bona fide need, I am bound to fail. My suit is liable to be dismissed. Then the second suit is with regard to the failure to pay rent for a certain period. That may also may not be found proved. So suit may again be dismissed. Now the third suit is on it altogether different ground. And the ground is failure of the defendant tenant to pay rent for continuous period of more than 6 months just before the institution of the suit. So now matter ultimately reached the Supreme Court because the trial court and the High Court took different views. And when Supreme Court was seized with the matter, they said that ultimately we have to see that whether matter directly and substantially in issue in the third suit is also directly or substantially in issue in the second or the first suit. They said, of course, the property is same. The relief is also same. Relief is eviction. Parties are landlord and tenant. Property is the same. But in the first case, the issue is altogether different. It is bona fide need. Maybe it is proved, maybe it is not proved. And in the second suit, again, it is failure of the tenant defendant to pay rent of particular period. But in the third suit, the ground is totally different. Now here it is the failure of the tenant defendant to pay rent, not to pay rent for continuously 6 months just before the institution of the suit. The Supreme Court expressed that there may be a situation that first and second suits are dismissed because the ground is not found proved. Still, the plaintiff may succeed in the third suit. And therefore, it cannot be said that the matter which is directly and substantially in issue in the third suit is also directly and substantially in issue in the previous two suits. This we can understand with another example. In that case, what happened? That plaintiff, who was a sub-inspector in the police, he was dismissed from the service. Now, he challenged the dismissal before the High Court on the ground that he was not provided fair and reasonable opportunity of hearing. And that is a ground, because that goes against the basic principles of the natural justice. The High Court, in the writ petition, heard the parties, and it finally came to the conclusion that the plea raised by the petitioner, that he has not been fairly heard or he was not afforded an opportunity of being heard, it is not true. So the writ was dismissed. Now, what he did, he filed another suit before the civil court, and in this case, he raised the plea that I was removed from service by Deputy Inspector General of Police, while my appointment was made by the IG of Police, and therefore the DIG of Police has no authority to remove him from the service. Now, in this case, an application was filed that the suit is not maintainable because this matter has already been heard by the writ court, by the High Court. And after consideration, the matter reached to the Supreme Court, traveled to the Supreme Court, and the Supreme Court said, now this is basically something which we can say that res judicata and constructive res judicata, but then this is the plea which was raised and which was not found maintainable. In another case, that is also a very, you see, important case, that is the National Institute of Mental Sciences versus C. Parmeshwaran. In this case, what happened? That this Parmeshwaran, he was found guilty of just, you see, diverting the medicines stored in the hospital and thereby causing substantial financial loss to the institute. So, after departmental inquiry, he was removed from the service. Parmeshwaran challenged his removal before the labor court, and the labor court, after due consideration, found that his removal from the service is not in accordance with the relevant legal provisions of labor laws. So he was reinstated. This order passed by the labor court was challenged by the institute in the High Court. At the same time, the institute filed a civil suit against Parmeshwaran for recovery of the financial loss caused by Mr. Parmeshwaran because of that diversion of the medicines. And in that suit, here the matter is pending in appeal before in the writ before the High Court, because the institute has challenged the order of the labor court, which found that the removal is not proper. And here the institute sought damages for the loss of the medicines caused by the defendant, who was petitioner in the labor court. Now, in this court, civil court, Parmeshwaran preferred an application under Section 10, and he said that this matter is also pending before the High Court. This matter was also there before the labor court. So therefore, this suit for recovery of money instituted by the department or by the institution is liable to be stayed. Ultimately, matter went to the Supreme Court, and Supreme Court found that the matter which is directly and substantially issued in the civil court is with regard to the recovery of damages, financial loss caused to the institute by the defendant. And in the High Court, where the appeal from the decision of the labor court is pending, the issue is different. It is not with regard to the recovery of money. It is with regard to the legality and correctness of the removal of defendant from the service under the relevant labor laws. So the Supreme Court expressed that both the matters are not substantially and directly same. Of course, the parties are same. Of course, the dispute has originated from the same source, loss of medicines caused by the defendant by his conduct. But then in both the cases, the matter is not directly and substantially same. So that way we can understand from these examples that how the matter may differ in the two cases, despite the fact that the parties are same, and sometimes even the subject matter is same, but the dispute, what we call, that is the disputed point of law and fact, which needs determination at the hands of the court, that is different. So these are the examples which very much you see, illustrate that what is ultimately matter directly and substantially an issue. Now the question arises that what is the scope of this principle, to what extent it is applicable. So one thing is that when we say that the court shall not proceed with the trial of a So what is trial of a case? Because sometimes it happens that there is another suit. Now there is an application under section 10. The application is either pending or is even allowed. But then plaintiff comes with the application for interim injunction that the defendant is trying to encroach upon the land or is trying to destroy the property. Therefore, he should be injuncted from interfering with the possession or from destroying with the property. Now, the question arises that whether trial of a case includes consideration of incidental issues which are involved in the dispute or in the case. Now, issue of grant of interim or temporary injunction is an incidental proceeding. Issue of appointment of receiver for the care of the property again is an incidental issue. It is not the trial of the case. It was found that trial of the case means settlement of issues, production of the evidence, examination and cross-examination of witnesses, hearing of the arguments, and judgment. That is the trial. So if the court is requested to issue a temporary injunction, or if a prayer is made by either party that the property in dispute is going to be damaged or destroyed or improperly managed, and therefore a receiver is to be appointed for the case, in that situation, the power of the court to deal with such incidental matters is not seized. What is seized? What is stayed? Is the stay is of the trial of the case, and consideration on the incidental proceedings doesn't amount to trial of the case. The next issue also arises that there is a second suit. All the conditions of section 10 are satisfied, parties are same, matter is directly and substantially in issue, court is of competent jurisdiction. But what happens that defendant fails to raise the plea at appropriate time, and ultimately a decree is rendered, a judgment is passed, a decree is rendered by the court. Subsequent, here there are always two courts, court in which the previous suit is lying, court in which the subsequent suit is lying. Now in subsequent court, the judge is very competent, proceeds with the trial, records the evidence, and renders a judgment followed by a decree. The question arises that whether a decree rendered in a subsequent suit is ineffective, is null, is void, or illegal in view of the fact that the subsequent court has conducted the trial despite the fact that there was a previous trial, previous suit in a competent court of competent jurisdiction dealing with the same subject matter between the same parties. Now this issue was decided by the Bombay High Court long back, and they came to the conclusion that this delivery of judgment and followed by a decree in the subsequent suit is something which is in accordance with law, and it cannot be treated either as illegal or as null and void. The reason being that the plea which was available to the defendant or plaintiffs, in some case it may be plaintiff also, because the defendant has come in the subsequent suit as plaintiff. So in that case, the plaintiff of the earlier suit has become defendant of the subsequent suit. So if the person who is defendant in the second suit has failed to raise the objection under section 10 of the CPC and court has proceeded with the trial of the case, despite the mandate of the section 10, the decree is well and good. It cannot be treated that the decree is either illegal or is null and void. This is also a very important aspect related to this principle. So then, one more important aspect of this issue is that if the trial court in the first suit or in the previously instituted matter has rendered a decision, now no trial is pending, and an appeal has been preferred by the party who has not been successful. So the appeal is pending, but the trial is over. And now a subsequent suit is also there, and an application is moved to stay the trial in the subsequent suit on the ground that the first suit is still pending in the appellate proceedings before the appellate. So then whether section 10 will apply or not, that is the question. So in this situation, we need to look at the principle that appeal is the continuation of the suit. The point matter goes to the appellate court, it is in continuation of the suit. So if the appeal is pending, despite the fact that the proceedings in appeal do not amount to trial of the case, and if we just technically say, then there is no parallel trials are now being conducted, because the trial in the first case is over. What is pending before the superior court is an appeal. So now the question of two parallel trials is not there. Still the doctrine or the principle of section 10 will be applicable, because appeal is continuation of the suit, and if there is an appeal, then it will be treated that the suit which was there in the earlier case, that is still being tried by the court, because there has not been a final and conclusive decision in that case. So that way we see that even if the previous court has decided the case, matter has traveled to the appellate court, still the second suit or the subsequent suit cannot be proceeded if there is an objection by the opposite party under section 10 of the CPC. So these are certain important aspects of section 10. So if we just put all the things in a very closer perspective, then first is that the parties should be same. And if parties are not same, then they should be privy of the main parties or should be litigating under their title. This you can understand by way of example, that a suit is preferred by A against B, and during the trial, A dies. So now his 4 sons are brought as legal representatives of the plaintiff. They are joined as successors of the plaintiff. And now the case is going on between these legal representatives of the plaintiff and defendant. Now, if one of the legal representatives prefers another suit with regard to the same subject matter on the ground that he is also a successor or he has succeeded to the rights of his father, then that suit will stand barred or will have to be stayed under section 10 of the CPC because of the res subjudice principle. Now we can further dilate upon the issue of what is matter directly and substantially in issue. Because this expression we find in sections 10 as well as in section 11. There may not be much difficulty with regard to the similarity or identity of the parties. But whether a matter is directly or substantially in issue, it has to be understood by some illustrations. We take first case that there is a dispute with regard to the title of the property between A and B. Now, during the pendency of the suit, A dies, leaving behind three sons, A1, A2, A3. Now, A1 and A2 claim by way of succession to the property. They are brought as LR. And C is also joined with A3 is also joined with A1 and A2. But A3 files another suit on the ground that the property in dispute has been willed by his father in his favor. Therefore, he is exclusive owner of the property. And now again this A3 prefers this suit against the same defendant in some other court of competent jurisdiction. The question arises whether section 10 will be applicable or not. Because here A1 and A2 are claiming on the basis of succession, and A3 is claiming in another suit. He is also party in this suit. He has been brought as a successor, but he says that I have become owner of the entire property on the basis of the will executed by my father in my favor. And he also prefers another suit. Now, in this case, the second suit or the subsequent suit is barred by the principle of res subjudice, because this ground of ownership on the basis of will has to be raised in the previous suit itself. Basically, it is directly and substantially an issue as regards title of A1, A2 or A3 versus B. So therefore, the subsequent suit or the second suit has to be stayed. But if we just slightly give a twist to this problem, and here what happens that A, B, C, they A1, A2 and A3. So there is an application by A1 and A2 on the ground that they are successors, and now there is an application by A3 on the ground that a will has been executed in his favor by the father. So therefore, he has acquired title in this case. Now, this is only a point which he has raised in the application preferred under Order 22 for being added as representative, legal representative of the deceased plaintiff. He has not raised this issue separately. So if the court examines this issue of will, now the only issue is that whether he deserves to be brought on record as legal representative of the deceased plaintiff on the basis of, so it is an incidental issue. This is not direct issue. So therefore, the issue of will in the first suit and the issue of the will in the second suit, in which the suit has been filed by A3 against the defendant, that is, they are not same. In the first case, it is incidental proceedings, simply bringing LRs on record in place of the deceased plaintiff. But in the second suit, it is the substantial issue. So in the first suit, it is incidental. In the second suit, it is substantial. That way we can distinguish between what is directly and substantially an issue and what is incidentally and collaterally an issue. So these are the principal aspects of section 10 of the CPC, which is based on a very important principle, because the objective or the purpose behind this principle is firstly that there are no simultaneous proceedings or trials with regard to the same dispute, which may lead to different or contradictory decisions in the same matter. Firstly. Secondly, the parties, maybe sometimes it is defendant, sometimes it is plaintiff, they should not be put to harassment with regard to the same issue in a next litigation or in a subsequent litigation, because this issue can very well be decided in the previous suit. And third is, it is the public policy that there should be no wastage of the resources if two parallel proceedings are taken by two courts of competent jurisdiction. Then definitely there will be wastage of time, wastage of resources, and as well as there may be new complications in two parallel suits. So these are the three objectives behind this principle, and this principle has been used at times, many a times, to prevent a subsequent suit being proceeded and tried, so as to avoid the possibility of conflicting findings or decisions. So this is something. Is there any question on these points? Same party, substantially and directly in issue, collaterally and incidentally in issue. So if the participants have any question, then we can discuss that question and then we can proceed further. Or should we discuss all the question at the end of the session?
So right now, I think they'll take a little while to type out their messages. We can take all the questions at the end. So if you wish to take a break in between, we can do that right now. Or if you wish to continue, we can do that.
No, we can continue.
Yes, sir. Yes.
We can continue. Now we go to the next part of the topic, and that is res judicata. Now, res judicata, res we know matter, and judicata means adjudicated. So it means that the res judicata means a matter already adjudicated. So res judicata again is a principle which aims at preventing two conflicting findings with regard to the same dispute between the same parties or parties litigating under them. The same principle is there. In section 10, it was with regard to the two suits which are pending in two courts of competent jurisdiction. But in res judicata, the position has slightly changed. Now, there are, you see, one case has already been decided and another case is pending. So res judicata means a matter or a dispute already adjudicated. And the mandate of the law is that if an issue which is directly and substantially involved in a case and that has been decided between the same parties or the parties litigating under them by a court of competent jurisdiction, then the issue will not be tried by in the subsequent case. That is the principle of res judicata. And if we just say that what is the origin, what are the regions, or what are the logic behind this principle, then what are the essential elements of the applicability of doctrine of res judicata, what are different other issues which we find in explanation 1 to 8 of section 11 of the CPC, what is constructive res judicata, and how we compare res judicata with estoppel and waiver. So these are some issues which we need to discuss with regard to the doctrine of res judicata. So if we just, meaning is very clear, res means matter and judicata means adjudicated, matter which has already been decided by a court of competent jurisdiction. That shall not be tried again. Either the entire issue, either the trial itself or any issue in that trial, the issue is decided in the earlier litigation. Now, this is basically based on the, you see, Roman maxim. There are three maxims, and the first one is res judicata pro veritate excipitur. It means that a judicial decision should be accepted as correct or as a truth. That is the first maxim. And basically, this expression res judicata is found in this Latin maxim itself. Now, this maxim is based upon two principles, which are expressed in two other maxims. One is nemo debet bis vexari pro una et idiom, means no one should be vexed twice for the same cause. It is the individual aspect of this principle that a person who has already went through a litigation with regard to a particular dispute, he should not be put to harassment or he should not be vexed with regard to the same issue in the subsequent case. And the public cause, it is the individual cause, and the public cause is interest republicae at sit finis litem, means it is in the interest of the state or it is in the interest of the state that there should be end of litigation. Because if litigation goes on in one or the other court on the same between the same parties on the same issues, then there will be no end of litigation and it will be simply, you see, wastage of the resources and time of the court. Apart that, it will put the parties to, you see, unparalleled harassment. So one is the private cause, that there should be no harassment to the parties, and there is the public cause, that there should be finality and end of the litigation. And on the basis of these two principles, the third principle emerges, that the final decision in any matter rendered by a competent court should be accepted as truth, should be accepted as correct, we can say. And that is res judicata pro veritate accipitur. So these are the three maxims and these are very important. Now we just, if you examine the importance of this doctrine, then the first thing is that it ensures finality of the litigation. Because if subsequent litigations, despite a decision on a particular issue by a court of competent jurisdiction, are allowed, then it may go one after another, and then there will be, you see, no end of the litigation. And disputes, if there is no end of the litigation, means there is no end of the dispute. So disputes will also remain there. So basically, it is against the, you see, social peace and tranquility. Secondly, if a person fights in a case throughout and obtains a decree in his favor, again there is a new litigation. So this new litigation is totally unfair. It amounts to harassment to that person, and therefore this doctrine aims at preventing harassment to the party against whom subsequent litigation has been brought. Thirdly, it maintains judicial efficiency because it prevents, you see, wastage of precious judicial resources. You see, when there is a, you see, two litigations, three litigations, and we find in many cases that party will go to different forums with regard to the same dispute. So that creates more complication. So to maintain judicial efficiency, it is necessary that there is finality to a decision when it has been rendered by a competent court regarding the same issue between the same parties or their privileges and by a court of competent jurisdiction. And the fourth importance lies in that it upholds the public policy, and the public policy is that is expressed in the Latin maxim that there should be finality and end to the litigation. Now, this principle has been incorporated in our jurisprudence in section 11 of the Code of Civil Procedure. And section 11 is very clear in its language. It says that no court shall try any suit or issue in which the matter directly and substantially in issue has been directly and substantially in issue in a formal suit between the same parties or between parties under whom they or any of them claim, litigating under the same title in a court competent to try such subsequent suit, or the suit in which such subsequent issue has been raised and has been heard and finally decided by such court. So this is the language of section 10, and if we just try to analyze this total, complete language of section 11 of the Code of Civil Procedure, then we will find that there are 5 essential conditions or 5 key elements necessary for the applicability of this principle. The first one is that there should be identical matter in issue. Now, what is identical matter in issue? That suppose now there is a claim of title about a piece of land by A against B. And this claim is based on inheritance. A says that I got a title from my father and I succeeded it, inherited it from my father. And the issue is tried by a court of competent jurisdiction. And ultimately it is decided against the plaintiff, and it is held that no, you have not inherited this property from your father, rather this is the property of B. Now later on, what A again files another action, and this time he says that I am owner of this land on the basis of adverse possession. So now, in both these cases, the issue is with regard to the title of the land. In the first case, it was on the basis of succession. In the second case, it is on the basis of adverse possession, but the same parties are there, the same subject matter is there, and the issue is also with regard to the ownership. Of course, the ground for issue in both the suits is little different. In first case, it is the inheritance, and in the second case, it is adverse possession. But here, the second case cannot be, will not be maintainable, for the reason that we will go subsequently, that if the A was having a ground of adverse possession, then he was required to raise this issue before the earlier court or in the earlier proceedings. Now he cannot be permitted to say that this time I am claiming ownership or title on the basis of adverse possession. So the subsequent suit will stand barred on the basis of res judicata. The second essentiality or the condition of applicability is that parties must be same or must be claiming through same person. So maybe that there is a breach of contract. A contract is there between X and Y, and X files a suit against Y, pleading that there has been a breach of contract and he should be compensated for the breach. Now the suit is dismissed. In the meantime, X also dies. Now a second suit is brought by the son of the X, Z, against Y, and again he says that there has been a breach of contract and there are certain other extraneous issues also, incidental issues also. But here the parties are same in the sense that this Z, he is not claiming the right, or the claim for compensation is not independent. It is simply on the basis of the fact that he is son of the ex-plaintiff who has died. So again, the judge is claiming through his father, and therefore there will be the conclusion that the parties are same, because in this case, judge is claiming through his father. Again, the third thing is there should be same title. Now, in both the cases, the parties must be litigating under the same legal title. Now, suppose here again A has filed a suit against B, and he is claiming recovery of a debt as the representative of an estate. Now, this suit is decided and the suit of the plaintiff is dismissed. It is found that there is no debt due against B. Subsequently, A files another suit, and this time he claims this recovery of debt on the ground that he is director of a company, and this debt was, as a matter of fact, due to the company, because the money was borrowed not from A but from the company. Now here the title is altogether different. In first case, the claim of plaintiff is based as representative of an estate, and in the second case, the claim is based as director of a company. So the capacity is different. Same title is not there. Here in the another case, the title is there of the company and the claim is on behalf of the company. In first case, there is there is a estate holder and the claim is on behalf of the estate holder. So in both these cases, now in subsequent case, despite the fact that the claim in first case has been heard and finally decided by a court of competent jurisdiction with regard to the same amount, but then it will not be res judicata because the title has changed. In first situation, it is a personal claim. In second situation, it is a corporate claim. So therefore, we cannot say that there is they are claiming under the same title. Then the fourth requirement is that there should be court of competent jurisdiction. Again, we can raise, that there is a dispute with regard to the possession of land, and then the proceedings are just taken on the criminal side for the possession, encroachment, and a case is preferred against B on the complaint of A that he forcibly dispossesses him from the property, but the criminal court or the court of judicial magistrate after due trial finds that neither A, who is the complainant in the case, owner of the property, nor he was in possession of it. And therefore, no case for illegal dispossession is made out in this present case. This is the finding recorded by a judicial magistrate first class in a criminal case. So now thereafter, A files a civil suit in the court of civil judge claiming to be owner and possessor of the disputed property. And in this case, the objection is raised that this issue was raised before the judicial magistrate first class, and the judicial magistrate first class, on the basis of evidence adduced before the court, came to the conclusion that A is neither owner of that property nor he was having possession of the property. Therefore, question of forcible dispossession doesn't arise. So now there is an objection that this issue has already been considered by a court and decided by a court, therefore it cannot be raised again in the civil suit. But here, the court of judicial magistrate first class is not a court of competent jurisdiction to decide the issue of title and possession. Of course, the issue of title was examined by the criminal court incidentally. It was considered collaterally, but it was not direct issue. direct issue is there in the civil suit where A claims that I am the owner of the property. A claims that I am the holder of this property, I am having possession of the property. So now in this case, the trial in the court of civil justice will not be barred on the ground of res judicata, because the decision or the finding in the earlier by the earlier court, that was incidentally, and it was not a court of competent jurisdiction to decide title. So that way we see that court of competent jurisdiction should also be there. And lastly, the fifth essential is that matter must have been heard and finally decided. So meaning thereby that if a matter has not been heard and finally decided, then it cannot amount to res judicata. Now heard and finally decided. So suppose there is a case. A files a suit against B for compensation or damages with regard to a car accident. He says that B drove his vehicle negligently, and he just there was an accident and he suffered injuries, and for the injuries he seeks damages. Now this suit is dismissed because the court fee has not been filed by the plaintiff within the time prescribed by the court. The court found that the court fee is deficient. Court directed the plaintiff to file the court fees, but it was not filed, so the suit was dismissed. Now, A again files another suit, same damages, same accident, same defendant, same ground, negligence. Now here, the plea is raised by the defendant that his suit has already been dismissed by the court when he failed to pay the court fees before the court. Therefore, how he can just raise this plea again in this? There is bar of res judicata. So here, the earlier suit has been dismissed not upon merits. The issue between plaintiff and defendant was never heard and decided. So therefore, the decision rendered in the previous case will not amount to res judicata in the subsequent case. Now, these are the 5 essentials for the applicability of res judicata, and we could just find with each illustration, each of the case, that how the applicability has to be decided. Now, next question is, what is the nature and scope of the doctrine of res judicata? If we go through the language of section 11 of the CPC, then it deals with the claim and issue. Claim and issue, we will read it. No court shall try any suit or issue. It doesn't say no court shall try any suit. It says no court shall try any suit or issue. So not only that the trial of subsequent suit is restricted or prohibited, the trial of an issue is also prohibited if that issue has been heard and decided between the same parties by a court of competent jurisdiction. So the second case, we will say that this is the first is claim preclusion, because the entire suit is barred by the principle of res judicata. And if the entire suit is not barred, there is only one issue which was common in the previous suit and this suit. So then the issue preclusion is there. Of course, the suit is not barred, but then court is barred from deciding or dealing with the issue which has earlier been decided by a court of competent jurisdiction between the same party. So this we say first is the claim preclusion and second one is the issue preclusion. Now, as I started, that this is a rule of universal application, because in each and every jurisdiction, it has been clearly understood that repetitive litigation with regard to the same dispute between the same parties is going to generate a lot of, uncertainty in the mind of the people, giving rise to so many problems in the society. So this rule we find in so many jurisdictions, but then as far as our country is concerned, if we go through the language of section 11 of the CPC, then we will find that this language restricts the applicability of this doctrine in many respects. And one of the respect is that the earlier court should be competent to try the issue raised in the subsequent, before the subsequent court or in the subsequent matter. So suppose if the issue has been decided by a court in the earlier proceedings and that issue is raised before a court of different jurisdiction or a higher jurisdiction, then technically the doctrine of section 11 will not apply. Of course, there has been an amendment in the CPC and it has been added in explanation 8 that if there is a decision by a court of limited jurisdiction, then still that will apply, still the doctrine of res judicata will apply in that case. But there are so many situations. Sometimes there is a case before the civil court, another case is before the high court, as we found in that case, that that fellow, sub-inspector, dismissal of the sub-inspector. So he first went to the high court and then he went to the civil court. So now these two courts are almost different jurisdictions are there. And if we just go by the technicalities of section 11, then the matter will not be covered. But here said that even if a matter is decided in the writ jurisdiction by the high court, and if the petitioners would have raised the other defenses or the other grounds for relief in the writ petition, and if didn't raise it, then by way of constructive res judicata, it will be treated that he has been heard on that point and the issue has been decided. So basically, it has been repeatedly said that because of the technicalities which are there in section 11, we cannot say that it is a comprehensive provision, but the Supreme Court and High Court have repeatedly said that where the doctrine of res judicata as contemplated in section 11 is not strictly applicable, still if the conditions, certain conditions are satisfied, then principles of res judicata will apply into the case. So sometimes there may be case, there was a case, suppose a writ petition is filed under Article 226 of the Constitution before the High Court. A matter is raised and the High Court, after due consideration, dismisses the writ petition on merits. Now the same point is raised by way of another writ petition under Article 32 of the Constitution of India before the Supreme Court. Now High Court naturally cannot exercise the jurisdiction under Article 32. That is the exclusive jurisdiction of the Supreme Court. And in the Supreme Court, if the plea is raised by the opposite party, this was the issue heard and decided by a court of competent jurisdiction in exercise of Article 226 of the Constitution. So then the plea will be there that the High Court is not having the jurisdiction under Article 32. So Supreme Court considered this issue, and in one of the landmark cases, Supreme Court said that no, despite the fact that the technicalities of section 11 of the CPC are not fulfilled, still there will be res judicata in this case, and if the High Court has decided, you can come to the Supreme Court by way of appeal against the order of the High Court, by way of SLP against the order of the High Court. But you cannot come separately by way of a fresh petition under Article 32 of the CPC. And this principle we found in Ghulam Abbas versus State of Uttar Pradesh. This is AR 1981. And another one is Satyadhan Ghoshal versus Devarajan Devi, AR 1960, Supreme Court 941. The case which I was talking is Daryao versus State of UP. It is AR 1961 Supreme Court. And in this case, the Supreme Court examine the scheme of section 11 of the Code of Civil Procedure, particularly in the context of the writ jurisdiction and the difference between the powers of the High Court and the Supreme Court, Article 26 and 32. And they said that of course the High Court is not exercising the jurisdiction under Article 32, but under Article 226, same reliefs which are granted under Article 32 can be granted by the High Court. Therefore, in such a case, in view of the public policy, there will be res judicata. So this is about the fact that the provisions are not comprehensive, and there may be some cases where the principles of res judicata are applied in an abstract manner. Now, if a question arises how to examine whether res judicata is there or not, then firstly, we have to see the competence of the forum. Secondly, we have to see that parties are either same or they are previous or representatives are there. Thirdly, we have to see that the matter in both the cases, subsequent case and the earlier decided case, are directly and substantially the same. And lastly, that the court, after hearing both the parties, you see, heard and decided, the issue was decided after due hearing. And we say heard and decided means assertion by one party and either admission or denial by the other party. So that is hearing about that issue. Even if there is admission, then it is hearing. If there is a denial, then evidence is required to prove that issue. Now, so these are the 5 conditions which can be applied to examine that whether or not the matter is res judicata. Now, one thing is that what is the difference between res judicata and estoppel? Now, estoppel is a rule of evidence and it precludes a person from changing his version with regard to a particular fact which has been made by another person to change his position. So we can say simply that A represents to B that I am owner of this property, you can purchase it from me. And subsequently, now what B has done, B has purchased the property, a sale deed is executed by A in favor of the B. Subsequently, A says that no, I was only leaseholder of this property, not the owner of the property. So that will not dislodge the rights. Now A is stopped from saying that he is only a leaseholder and not the full-fledged owner of the property. And suppose subsequently in a situation it comes that he acquires ownership of the property, then the transaction between the two persons will be held right, and the person will not be allowed to change his version. Of course, he is not owner at that time. He is simply a lessee, but then he will not be, and there will be an estoppel against him, estoppel that he cannot neither plead nor lead evidence that he was not owner. That is estoppel. But then res judicata is a rule of procedure. Estoppel is a rule of evidence. Res judicata is a rule of procedure, and it restricts the court. It prohibits the court from trying a suit or issue which has already been heard and decided by a court of competent jurisdiction. Now, after this, we need to just have a look at the 8 explanations which we find in section 11, including explanation number 4, which distinctly deals with the doctrine of constructive res judicata. So the explanation 1 says that what is former suit? Now you see section 11 says that a court shall not try a suit or a issue which has been directly and substantially involved in a matter which has been decided earlier by a court of competent jurisdiction. So now, which is this earlier suit or which is the former suit for the purpose of section 11? So with this, in this respect, section 11 explanation 1 says that for the purpose of section 11, former suit is one which is decided former in point of time, not instituted in point of time. So suppose one suit is filed in January 2024, another suit is filed in June 2024. By November, the second suit is decided, the first suit is still pending. Technically, the first suit is the former suit, but for the purpose of section 11, the second suit which has been decided in November and the previous suit is still pending. So the second suit for the purpose of section 11 be treated as former suit because now it is decided. So this decision, if other conditions are satisfied, will amount to res judicata. Then second, we have already competence to be determined. Of course, competence, but then determining the competence, the question of right to appeal will not be there, will not be whether appeal is there or not. There may be a case from one court, the appeal is there, in another court is appeal is not there, but then that is immaterial. It is only competency to deal with that. Then we have already discussed what is matter which is alleged by one party and either admitted or disputed by the other party. Then fourth, very important one, matter deemed to include a matter which might or ought to have been made a ground of defense or attack. And this is the doctrine of constructive res judicata. We will discuss it at length subsequently. Before that, we go to clause 5, which says that if a relief has been claimed by in a particular suit and that has not been expressly granted or expressly denied, neither it is granted nor it is, then in such a situation, it will be presumed, it will be deemed that that claim has been denied. So one cannot say that it is undecided. The deeming fiction will be that it has been denied. Then, if there is a litigation by a person or group of persons with regard to a public right or a private right claimed in common, private right claimed by so many persons, but then only few persons are litigating, or it is a public right claimed by only 3 persons, that it is a public way, but then it is in the use of the many persons, then for other persons, it will amount to res judicata if it has been decided in that very manner. So this says that persons litigating bona fide for a public right or private right claimed in common for themselves and others, then all persons interested in such rights shall be deemed to be claiming for all, and then principle of res judicata will apply. Then clause 7, that section 11 is applicable to proceedings in execution also. And last is that an issue heard and finally decided by a court of limited jurisdiction will also be res judicata. This provision was not there in the original code, but subsequently when certain problems arose, that it was added that if the issue is decided by a court of limited jurisdiction. So we can just understand that there is a issue, there is a dispute between A and B, and the relationship of landlord and tenant is disputed. A says that I am landlord and B is my tenant. B says, no, I am not tenant. I am just holding it in my independent right. Now the rent court or the court of small causes decides that there is a relationship between them of landlord and tenant. Now this relationship is again disputed in a civil court. Now this court of small causes or rent court is a court of limited jurisdiction, and civil court is having wider jurisdiction, and that dispute is again there. Of course, in a different situation, here A is claiming title. And he says that this is the person has I inducted him as a tenant and he has just is not leaving the premises. So now this point of relationship of landlord and tenant, this is res judicata. This cannot be re-agitated. So these are the 8 explanations. Now we come to constructive res judicata. Now, this is a beautiful principle in the sense that it prevents a person from manipulating in the litigative process. There may be some parties, okay, there are 4 grounds for claiming a right. We first time we will use only one. If the relief is granted, okay, then we will go for the second suit, taking second ground. Again, it is not granted, we will take third ground, then we will take fourth ground, so on and so on. Sometimes I will say that it is on succession, then I will say that it is on a will executed. Third, I will say that I am owner by adverse possession. Fourth, I say that it was a grant by by the previous owner. Now there are different grounds, but I am in all these cases I am claiming title or ownership to the property. So I will have to be raised all the grounds in that very suit. I can't say that in first suit I will raise this ground and in second suit I will raise this ground. And if I don't raise all the grounds, then it will be deemed that all those grounds have been raised and decided. That is the deeming friction, and this prevents the mischief which a very clever plaintiff can do by restricting certain grounds and just putting them in another litigation. But with this proposition, constructive res judicata, clause 4 of section 11, the plaintiff will not be permitted to raise those grounds again. Now, this ground of this constructive res judicata to some extent appears to be just matching with the rule which we find in Order 2, Rule 2 of CPC. Order 2, Rule 2 says that if there is a cause of action, then all the claims under that cause of action should be put in one suit, and there can be no division of the reliefs. If the claim is same, you have to claim all the things, and if you don't claim all the things, then you cannot claim subsequently something in the another suit. So suppose you want to recover certain sum of money and say, okay, in this case I only require 10,000, 5,000 will be required. No, you can't do it. Either you have to take leave of the court, else you will not be permitted to bring a second suit by way of Order 2, Rule 2, which says that suit should include whole claim. It is not that you claim only part, and if you don't include whole claim, the part which you have not included in the suit, that will not be used, cannot be used in the subsequent suit as a ground. So this is basic difference between the constructive res judicata and division or bifurcation of the reliefs under a claim. And this constructive res judicata, we have already discussed, it has been very beautifully dealt with by the Supreme Court in the case where a sub-inspector, he was removed from service. And as I discussed earlier, in firstly, he preferred a writ petition that my dismissal is bad because there was no adequate opportunity of hearing to me. High Court considered the matter and said, no, you were afforded sufficient opportunity, therefore your claim against dismissal is not maintainable. The writ was dismissed. Then this fellow goes to the civil court and says that I was dismissed by the DIG, whereas my appointment was by IG, and as per law, only person who is the appointing authority can remove a person from service. So therefore, my removal is bad. So in that case, the government raised the issue that the plea is barred by res judicata, constructive res judicata. He was at liberty to raise this plea before the High Court. Why he didn't raise? So in that case, again, matter traveled to the Supreme Court, and Supreme Court said, of course, because the defendant has not raised the plea before the High Court, though he could have raised it. Therefore, the principle of constructive res judicata will apply, and he cannot be allowed to prosecute the next suit, and that is barred by the principle of res judicata. Now there are certain exceptions to the principle of res judicata. First is that if a judgment or decree is obtained by fraud or collusion, then it will never amount to res judicata. Such a decision can always be challenged or if anything is there in such a decision, then that can be claimed in the another suit, and it can be pleaded that the whatever was decided in the earlier case, that was on the basis of fraud or corruption. That is the first exception. The second exception is that if there is lack of inherent jurisdiction in the court, the jurisdiction itself is not there in the court and the court has decided the case, then such a decision is never res judicata, because the court should be a court of competent jurisdiction. So if it is found that the court was lacking inherent jurisdiction, then principle of res judicata will not apply. And thirdly, there can never be a res judicata with regard to the decision on the point of jurisdiction. The law is that every forum, every court has inherent jurisdiction to decide about its own jurisdiction, whether it has jurisdiction or not. Now, if such a decision is given, a court says that no, I am not having jurisdiction in this case, therefore I will not entertain the case. So, whether this decision will amount to res judicata? No. Any finding of either having the jurisdiction or not having the jurisdiction will never and can never amount to res judicata, and this was authoritatively laid down by the Supreme Court, a 3 judges bench of the Supreme Court in Mathura Prasad versus Doshi by AIR 1971 2355. This is a landmark decision. Subsequently, in another case, it is I think sometimes 79, Avtar Singh's case, the court said that no, it is res judicata. Decision about own jurisdiction, court's own jurisdiction by a court is res judicata, but then this error was corrected later on in sometimes in 2005, and that is the case of Raptakas Brats. Also, the Supreme Court said that there is already a settled legal position by way of 3 judge bench decision in Mathura Prasad's case, that a decision on the point of jurisdiction, a wrong decision on the point of jurisdiction will never amount to res judicata. So that is the law. And the fourth exception is writ of habeas corpus. Habeas corpus means just bring the person before us. Why he has been detained or why she has been detained. And because every day's additional detention gives rise to a new cause, therefore it has been held by the Supreme Court in the case of Ghulam Sarwar, 1967 Supreme Court, that a finding or a decision in a writ of habeas corpus can never be res judicata. Now, certain issues has been raised whether public interest litigation and writ petition, whether res judicata will apply, and law has been settled many a times, including in the case of Raj Lakshmi Dasi, 1953 Supreme Court, that it will amount to res judicata. Because, of course, all the persons have not come, a representative or a section of the people have come, but then the issue has been decided, and to the almost about the writ, parallel jurisdiction of the High Court and Supreme Court. That is the case of Darya versus State of Uttar Pradesh, that if there is a dispute heard and decided by the High Court, then the same issue cannot be raised before the Supreme Court under Article 32, because that will amount to res judicata. So these are principles with regard to writ jurisdictions. There may be a question whether this principle applies to co-plaintiffs or co-defendants. Co-defendants means all the parties are defendant, and now in another litigation, one defendant says against the another defendant who is the maybe opposite party that it is res judicata. So then it has been held that if there is a dispute, real dispute between the co-plaintiffs and co-defendants, first thing. Second thing, that this dispute is required to be decided for the decision in the case. If it is not necessary, it cannot be res judicata. But then this decision is required to be decided by the court, and it has been accordingly decided after hearing the parties. If these three conditions are fulfilled, then the principle of res judicata may apply between co-defendants and co-plaintiffs. So this is something very clear, and always there can be a waiver. A decree is passed if there is a waiver, and if a decree is passed in violation of the rule of res judicata, then that will not be a total illegality. So this rule requires that the parties should be vigilant while prosecuting the case, and if a plea is available, then that plea should be res judicata. Now at the end, there may be a question in your mind that what is the difference between res subjudice and res judicata. So first thing, that one, res subjudice to parallel trial in two cases with regard to the same dispute between the same parties, while in res judicata there is a bar for the subsequent trial. In both the cases, the issue should be directly and substantially an issue. If there is a section 10 res subjudice, then in both the cases there should be a substantial identity of the dispute, and same is applicable for the res judicata. Section 10, section 11 we know, and rest of the conditions remain similar. The objects are similar. The public policy is same, and you see, if you compare both these provisions, while in section 10 you see previous former suit and earlier suit, in res judicata section 11 you say matter already heard and decided. So here there is one case pending and another case has already been decided. So these are the subtle differences between the two. Now we can address certain questions which may be there in the minds of the participants.
Yes, sir. So, we have two questions from Prakash, but I believe that they've been answered by you during. So he has asked what are the exceptions and whether res judicata is applied to
Exceptions
PIL.
for
Yes,
exceptions for that is one that is fraud and collusion, and then exception no res judicata about decision on jurisdiction. That is also there. Then habeas corpus is also there.
Yes,
these are the exceptions.
Yes, sir. So there's a question: if a dispute is already pending before the deputy registrar who has specific powers. So am I audible? So am I audible? Wait, sir, am I audible?
Issue with regard to your not audible. Can you just give it in writing?
So I'm audible?
Yes, yes.
Yes, sir. So actually, there's a little bit of a storm for me outside. So the question is, if a dispute is already pending before the deputy registrar who has specific powers to adjudicate the matter, and the same dispute is subsequently filed before the consumer forum, will the principle of res subjudice apply, particularly in light of the potential of duplicative proceedings, wastage of judicial resources, or harassment of opposite party, even though consumer forum exercises concurrent jurisdiction?
You see, in this you see situation, firstly, neither is court. Neither consumer forum is court, nor the registrar is court. Of course, they are exercising some quasi-judicial powers. They are not court. And section 10 is strictly applicable with regard to the two courts, civil courts exercising the jurisdiction. So in these two cases, the question of res judicata will not apply. The proceedings may go on. The registrar is having a very limited type of jurisdiction under the Societies Act or the Cooperative Societies Act. And the consumer forum is having altogether a different jurisdiction under the Consumer Protection Act. So they can proceed with their process.
Right, so thank you, sir. So another one, if one case is of civil nature and on the same set of facts and some same parties in a criminal case having criminal aspect is also registered, is the doctrine applicable? So I think Anmol is trying to ask.
We have already discussed it. I gave an example that issue of the possession and title raised in a criminal case, and it can be examined by the criminal court because the issue has to be decided whether it was illegal enforceable disposition. But then this is incidentally and collaterally decided. Basically, the title and possession has to be decided by the civil court of competent jurisdiction. So finding recorded by the magistrate will not be res judicata for civil court.
Right, sir. So another question. So in the beginning, so you had mentioned two examples. One of them was regarding a police officer removal by a higher authority, and another was medical funds allocation by an individual. So this participants wants you to just briefly explain these examples. Yes.
Actually, these are very, very important. And in this case, need of mental sciences. Am I audible?
Yes, sir. Yes, sir. So can you repeat the case name if you were taking?
National Institute of Medical Sciences versus Parmeshwaran. In this case, what happened? That it is a case of 2005. In this case, there was a person who was senior pharmacist, and he misappropriated medicines to the extent of some 2 lakh rupees. So what happened? A disciplinary departmental inquiry was held against him, and he was removed from service. Now he challenged this removal as usual before the labor court. And labor court has applies its own principles, labor law. And on the basis of those principles, the dismissal of this fellow was held to be bad in law. Matlab ki dismissal was reversed.
Okay.
Now the government challenged the dismissal in the High Court by way of writ petition, because no appeal is available. And in writ petition they said that this dismissal is bad. In the meantime, government also filed a civil suit against this fellow in the court of competent jurisdiction, that because of this fellow, we have suffered a loss of around 2 lakh rupees, and therefore you should compensate the government by 2 lakh. Now, in this case, he raised the issue that no, Section 10 will apply and this suit cannot proceed. So, Supreme Court said that the dispute in both the suits is not directly and substantially same. In one case, it is the labor law and the entitlement to the job. In another case, it is the pecuniary or financial loss caused to government by a person, and if the loss is caused, then it has to be recompensated. So they said that these are totally different issues and no identity, therefore Section 10 will not apply. It was in this case of National Institute. And then the other case, as I told you, that was a case that a sub-inspector is removed from service by, it is a government of Uttar Pradesh. He challenged his removal firstly before the High Court on the ground that I was not afforded adequate opportunity of hearing. That is a ground. High Court considered the issue and said that no, you were afforded sufficient opportunity, therefore your dismissal is okay. Now he was advised that you have been removed by DIG while your appointment was by the IG, and the DIG cannot remove a person who is appointed by the IG. So now he files another suit before the civil court that DIG has no authority to remove me, it should be declared. Now here the government raised the point that you were at liberty to raise this point before the High Court also. Why you didn't raise? So Supreme Court said that of course the matter was decided by the High Court, but then before High Court this issue ought to have been raised. Therefore, constructive res judicata explanation 4 of section 11 will apply, and you cannot raise this issue before the court. Res judicata.
So can you tell me the name of the second case?
Second case is, I just let you know, this is, just a minute. This is State of Uttar Pradesh versus Nawab Hussain, AIR 1977, Supreme Court 1680. Police sub-inspector. And
Thank you, sir.
that I already told.
Yes, sir.
And this issue is also, this case is also very important. Aspijal,
Yes, sir.
something, it is a landmark decision on Section 10, in which the three civil suits were filed before small causes court. One
Yes, sir.
on the bona fide need, another on the non-payment of rent, and third one non-payment of rent for more than 6 months. That is also a very important case. Any question? Any other question?
Yes, sir. We've quite a few, sir.
Yeah,
So
yes,
there's
good.
another. Yes, sir. So there's another. What if new documents raising new grounds appear which plaintiff had no knowledge until judgment in title dispute? If allowed, is there limitation period after judgment? Utkarsh, I think your question is more on limitation and not on the issue of res judicata.
Limitation will lie as per the Limitation Act 1960. The provisions in the Limitation Act, when the limitation will commence and when it will conclude, are very clear, and we have to go by the respective provisions of the limitation law.
Right, sir. So there's a question, does res judicata apply in case of decisions passed by administrative bodies exercising quasi-judicial powers?
No. You see, at res judicata requires two courts of competent jurisdiction. Any administrative body is not a court of competent jurisdiction. Court means in that there is a pleading, there is evidence, there is hearing. So administrative decisions are challenged in the court. If we say that the administrative decision is res judicata, then there can be no challenge to the administrative decision. So the question of res judicata is totally inapplicable and foreign when it is a matter decided by administrative authority, because it is always open to be challenged by way of civil suit when possible, or by way of writ petition.
Right, sir. So what happens when a party fails to raise plea of res judicata and contradictory decisions are upheld by two competent courts?
You see, in res subjudice and res judicata, there can be waiver. Waiver will be acquisitions, means the party is not just raising or has not no knowledge. And in such a situation, if two decisions are rendered and they are contradictory, then definitely decision rendered in the previous issue shall be operative.
Right, sir. So does res judicata apply to claims arising from continuing cause of action, for example, in case of trademark or copyright infringement cases?
No. Continuing cause of action, I said that in habeas corpus, it is not applicable. In this Aspij's case, it was you see, cause of action was changing. In the second and the third suit, the ground was same, non-payment of rent for sufficient time. But in the third suit, they said that the non-payment for more than 6 months just before the institution of the suit. So it was same, it was continuing, but it was different.
Right, sir. So can doctrine of res judicata be invoked against a person who was not a party to the former suit but claims under one of the parties?
See, if a party is claiming as a representative or privy to a party in the previous suit, then it will be res judicata. If I claim through that person, if I claim through father, if I claim to the person from whom I have purchased the land, of course, there is no blood relationship. But if I am claiming to the person from whom I have purchased the property, so suppose if he has litigated already and his claim has been accepted or denied. Suppose I purchased a property from A. Already there was a litigation between A and B with regard to the ownership of a piece of land. A lost the suit. Now I am the purchaser. Can I file a fresh suit? No. Because I am claiming through A and A has already been denied the relief. So now I cannot re-agitate it because my claim is only through the A. What I got is only through A. If A is not the owner as held by the court, then I cannot claim. Res judicata will apply.
Yes, sir. So if administration passed arbitrary order against any person which is against the doctrine of res judicata, like a man suffered various punishment in an action ordered by administration, then the court can apply this principle and quash the order.
You see, we must be very clear that the principle of res judicata has nothing to do with administrative decisions. All the administrative decisions can be challenged before the competent forums on the ground of, you see, hearing opportunity not granted, discrimination, Article 14, Article 21, or illegality, not following the procedure laid down in the statute, imposition of tax. In all such cases, you see, any administrative decision can never amount to res judicata. Basic line.
Understood, sir. So we'll just give a few more minutes for everyone to type out their doubts. So in the meantime, I'll just discuss the judicial services examination course that we've launched. Also, I want to assure all the participants that whoever has joined our WhatsApp group, we've made, sir, a WhatsApp group actually for all the participants to join in and to facilitate sharing their questions with us and having a more meaningful discussion. So I will be posting all these case names with complete citations in the WhatsApp group. You need not worry and need not wait in the chat box after this. In the meantime, so I'll just take few minutes with your permission to just share my screen and show you that we've launched 2 courses. One is Judicial Services Examination Preparation course, which is JSIP 2.0. So, sir, this is basically, and for all the participants, this is an extension of our flagship course, which we had the last time, which we launched in January. And this is an annual subscription of LiveLaw, our news portal, free. And there will be weekly tests, subjective and objective. There will be a case compilation provided, detailed notes will be given, and the recordings will be there for 1 year after the course is complete, right? So if your CPC classes get complete, let's say in September, then until September 2026, you will have all the recordings available. There will be dedicated doubt clearing sessions, and our special focus is on general knowledge and GK and current affairs. And Ved sir has so graciously agreed to teach CPC for us in that batch. We are just honored for that. And we will comprehensively be covering 45 subjects in JSIP 2.0. So we have another course, which is JSIP Lite. So this is basically for students who do not have a lot of time or professionals who do not have a time. And we've specially curated 29 subjects. And the classes will go on from Monday to Friday for this batch. And it's a comprehensive coverage. Although their notes will not be provided, but live classes will be there. The recordings will be there for a month. And there will be a final end of subject test. So you can join either of these 2. There is a quick comparison table here, which I'll share and quickly tell you. So right now, the course fee, what written is that for webinars, we are offering an early bird discount, and for exclusively for participants of our webinar, a 30% discount right now. And you can see the comparison table, and you can see that although JSIP 2.0 is more extensive with 45 subjects and classes which are there on Saturday and Sundays as well, but it will be a comprehensive coverage. So even if you're not a judicial service aspirant, otherwise also I think that this course is going to be very beneficial for you, where you'll be able to cover almost all the laws under the sun, which you deal on a day-to-day basis. If you have any questions, you can write to me in the WhatsApp group, or you can also mail us. You can call us. If there are any other questions, we are more than happy to take them up right now. So on this note, I believe that we are done with our doubts. And so I just want to extend a very, very, very warm thanks to you. Thank you so much, sir, for this enlightening session. Your profound insights on this doctrine of res judicata and res subjudice are just ingrained in all of our heads, all of our minds for life. And I'm certain that everyone present today has gained both clarity and appreciation for these fundamental concepts, which was absolutely needed, sir. There was a gap for this. And we are so grateful to have you with us, sir. And everyone can write to us for other topics if they want to have. And we'll do more webinars. And I hope to see you all in our classes with sir, starting 1st of May. The class will be from 5:30 to 7:30. So I suggest you that you take the discount right now, 30%, and we all will see you in the classes. Join the WhatsApp group and let's get connected. Thank you so much, sir. My heartfelt gratitude to you, sir. Abish, I will be mentioning all the case law names in the WhatsApp group. Please join the group. I'll give you a list of all the case law names there.
I refer to a decision from Bombay High Court.
Yes, sir. So please tell me, sir. I'll share that as well.
That is AIR 1980 Bombay 188.
Yes, sir. So I'll share that as well.
Yeah.
Absolutely,
And
Muskan. Yes,
one
sir.
very important decision on waiver.
Yes, sir.
Waiver, that is by Justice Vivian Bose. And it is AIR 1937 Nagpur.
Yes,
He
sir.
said, Justice Vivian Bose said that provisions of Section 10, though mandatory, could be waived with the consent of the parties. It is no doubt true that the institution of a second suit is not barred by Section 10 CPC. Institution is not barred. Trial is barred. But all that is prohibited is the trial of the subsequent suit. Instituted in case the question involved in two suits are substantially the same. And if the decision is rendered in the subsequent suit, by the way, then that is good enough.
Right, sir. So I'll be sharing all these insights and all these case law names in the WhatsApp group. So we couldn't have ended on a better note than Justice Vivian Bose's statements, and such an enlightening session from you. So we are deeply indebted.
Thank you.
Thank you so much, sir. Thank you everyone for joining in.
Okay. Thank you.
Thank you, sir. Have a great evening.